So we met in the middle, and I became a computer detective.
All right, sir. Well, what experience do you have in that field?
Well, I first got my start in computer forensic analysis at the Midlands Police Department 7 years ago, and 2 years later, I moved over to the private sector. Over that time, I've analyzed over 2,000 devices, things like computers, tablets, cell phones, anything with wires in them.
Do you have any professional affiliations or certifications?
I do. I'm certified as a cell phone forensic analyst by the U.S. Department of Justice, and I've served twice as an instructor for the FBI's data recovery seminar down in Quantico.
Well, sir, have you ever testified in a court of law before?
Yes, I've testified 14 times before trial today.
How did you become involved in today's case specifically?
My firm was contacted by the Ginger campaign to review the cell phones of individuals in Truman City who reported receiving fraudulent calls. I was the one who was put on the case.
And for full disclosure, are you being paid for your testimony here today?
For my testimony here, no, I'm just paid my regular salary by each of them.
All right, Mr. Garcia. During your investigation, did you use methods that are standard in your field?
And I did. I primarily relied on what's called the Sebastian Physical Analyzer, or SPA software. It extracts and analyzes all phone records and data and puts them into a nice format so I can look at it and form my conclusions.
To the best of your ability, did you reliably apply those methods to your work in today's case?
And I did, sir.
And finally, sir, did you have sufficient facts and data to reach conclusions in this matter?
Absolutely. I personally went to the home of 171 District 12 residents who reported receiving fraudulent calls. Of those people, 118 provided me their cell phones for inspection. I also was given access to the cell phone of Mayor Maxine Heisman and her campaign manager, Tom Lyon.
Well, let's start with the phones that you gathered from District 12 residents.
Okay.
What were you looking for on those?
The first thing I wanted to find out was whether the communication those phones were receiving were coming from the same sender. Now, the Sebastian software is able to quickly extract and identify any shared phone number among the contacts, text history, or call records of a set of phones. It quickly identified one number, 625-555-1935, as having contacted and messaged each of the phones I analyzed.
Were you able to see what message it sent?
I was.
Would you recognize a copy of that message if I showed it to you?
No, of course.
Your Honor, let the record reflect I'm approaching the witness, the plaintiff.
Which number is that? Which
The
number is
plaintiff's
that?
one, Your Honor, the text
That's
message.
already admitted, correct?
Yes, Your Honor.
All right. Take a look at that, sir.
I will, sir.
Mr. Garcia, do you recognize what I just handed you?
I do. This was the text message I was telling you about, the one that I found on every one of the 118 phones I reviewed.
Were you able to determine if that text message or if the 625 number sent any text messages to any other phones besides the ones you reviewed?
I was. That's exactly what I wanted to figure out. So I looked at a reverse telephone directory to figure out that this 625 number was managed by a wireless carrier named NetSource. I contacted and received NetSource's records of this phone number's usage.
Would you recognize those records if I showed them to you now?
Absolutely.
Your Honor, permission to approach opposing counsel and the witness in turn with what's been marked as plaintiff's spot.
Of course.
And would Your Honor like a copy for reference?
Yes, I would. Thank you.
Absolutely. Mr. Garcia, can you tell the members of the jury what I've handed you?
Sure. This is the record I was telling you about. It's accompanied with a certification by a technician at NetSource.
We offer plaintiff's 5, Your Honor. Its authenticity has been certified by this certifier from NetSource and thus meets an exception.
We have no objection, Your Honor.
All right, it's admitted.
Sir, how many text messages did that 625 number actually send?
The 625 number sent a total of 745 text messages.
Did the phone make any calls?
Yeah, it did. It made 1,656 calls.
All right, sir. When you identified those records, were you able to use any of the information to trace the 625 number to its owner?
Unfortunately, no. It was a prepaid burner phone, meaning no owner was registered, and it was purchased in cash at a convenience store, so it's not like there was any credit card information I could trace.
All right, sir. I'd like to move on to the phone of Mayor Maxine Heisman, which you mentioned you reviewed.
Of course.
What specifically were you looking for on that phone?
No, I reviewed Mayor Heisman's phone after I learned about the 625 number and the type of incorrect text messages it was sending. So I wanted to look for any communication or connections between Mayor Heisman's phone and that 625 number.
Did you find any connection?
I did. I found that the 625 number was saved as a contact in Mayor Heisman's personal cell phone.
Were you able to figure out how that 625 number got into the mayor's cell phone?
The Sebastian physical analyzer told me that the only way this number could have been saved as a contact in the mayor's phone is for someone to have physically punched in the digits and pressed save on that phone itself.
Sir, is it possible
Objection,
that...
Your Honor. Lack of foundation. May I be heard?
Sure.
He hasn't provided any foundation as to how he would know that it had to be entered manually digit by digit as opposed to something like being synchronized to a computer or to a server. Until he lays that foundation, he can't make that conclusion.
Mayor Spondra, the witness has already testified that he specifically used a device called the Sebastian Physical Analyzer. We've already heard testimony that that device is widely used in the field and is considered to be reliable by people in Mr. Garcia's field. He mentioned that he specifically used that device, and by looking at that device as well as his background knowledge, he was able to determine that that was how the contract was entered into the phone. There's certainly foundation.
May I be heard, Your Honor?
Yeah.
He can't just say that he used this software and that the software told him that it had to be manually entered digit by digit. At the very least, he needs to lay some foundation as to how he knows, based on the software, based on the output of the software, whether it was entered digit by digit or synchronized or something else. Until that foundation is laid, he can't provide that testimony.
If I may, Your Honor, it's my understanding from the witness's testimony that this was a specific piece of output from the software. In other words, he saw from using the Sebastian Physical Analyzer that that's how the contact was entered.
Okay, I'm not sure that I'm clear on that, and I'm not sure the jury's clear on that, so let's go back, retrace some steps and lay a foundation and get where you're going.
Yes, Your Honor. How are you able to determine how that 625 number was entered into the mayor's phone?
It's through the same software I was telling you about, the Sebastian Physical Analyzer. Now, it doesn't only just produce text histories and call records and identify shared numbers. What it does is it gives you a picture of that phone's lifetime. It tells you when different contacts were stored, how they were stored, what text messages were sent, what were received. It's through the Sebastian Physical Analyzer that I figured out that this phone number was manually entered onto the phone itself.
Well, is it possible that the phone number could have gotten onto the phone from some other computer or tablet device?
No, sir. Like I said, it had to be manually entered into the phone.
Well, I'd like to step back a bit and talk about the 625 number. Well, when were those calls and texts sent?
Well, I actually brought along a diagram to help explain what the phone's activity was.
Permission for the witness to step down.
Yeah, hang on. There's no objection to this demonstrative, right?
No, Your Honor.
All right. Yeah, you may.
Thank you, Your Honor.
Counsel, if you need to park yourself over here by the camera, you can.
Yes, Your Honor. Thank you.
All right. Hang on a second. Let counsel get in position, please.
Of course, Your Honor. Matt?
Yeah.
Sir, I'd like to start with the phone itself. You mentioned it was a burner phone. Were you able to determine when it was purchased or activated?
It was purchased on February 28th. That's why I'll write February 28th over the image of the cell phone.
Were you able to determine what time the 625 number was entered into the mayor's cell phone?
That same night. The 625 number was entered into the mayor's cell phone on the night of February 28th at 11:30 p.m. That's why I'll write February 28th over that.
And sir, when did the first calls and text messages begin?
The calls began on March 1st, just a day after the phone was purchased and saved into the mayor's phone. That's why I'll write March 1st over this arrow, and the text messages were all sent on the morning of the election. That's the morning of March 17th. And so I'm writing March 17th over that.
Thank you, Mr. Garcia. No further questions, Your Honor.
Thank you.
And would opposing counsel like me to leave up or take down the demonstrative?
You can leave it up. Thanks.
You want to resume your chair, please?
Yes, sir.
Counsel?
Yes, Your Honor. First, can I ask permission to maybe move the demonstrative? I don't know if the witness will be able to see it.
That would be great, sir. Or I can step down if you want.
No, you can put whatever you want to, counsel.
Thank you, Your Honor. Can you see this okay, Mr. Garcia?
I can, thank you.
Your Honor, I just asked that I be allowed to see the witness.
Hang on, can the jury see it?
Yes.
Okay, please.
I just asked that I be allowed to see the witness.
Sure, then move around the room.
Yes, Your Honor.
Good evening, Mr. Garcia.
Good evening, how are you doing?
I'm good, how are you?
I'm doing great.
Just got a few questions for you, then we'll get you right out of here, okay?
Of course.
You said you work in electronic forensics, is that right?
That's right, sir.
You'd agree with me that there are some things that forensics can't tell us. Isn't that true?
Absolutely.
You talked about how you found that number in the mayor's phone, right?
That's right, sir.
Council drew this arrow from the city hall, it looks like, to the phone?
I do that, but yeah, that's right.
Sure. But you can't actually say that the mayor entered that number into her phone, right?
No, sir. Just that it was saved at 11:30 p.m. on February 28th.
Right. Forensics can't tell us who entered a number into the phone, right?
That's right.
Can't tell us if it was her secretary,
I suppose if her secretary had her phone at 11:30, sure, that's possible.
if it was her husband,
Sure, that's right.
campaign staffer.
Of course.
So you can't tell us what was going through the mayor's head at all when this number was saved into her phone.
No,
Can
I can't read minds.
What forensics can tell us, though, you'd agree, is that forensics can tell us between the mayor's phone and that 625 number, there were no texts,
Yes, that's right.
there were no calls.
That's right. The
There-
only evidence of interaction was the contact being saved.
Right, there was no instructions to commit fraud, right, Mr. Garcia?
Uh,
Sent via text message, nothing like that?
That's right.
You mentioned that you got access to Mayor Heisman's phone. You got access because she gave it to you, right?
That's right. It was with the specific conditions of only being allowed to look at communication history and the contacts. I wasn't allowed to look at anything else.
Right, but the instructions or the understanding based on your knowledge is that you'd be able to look through her contact list.
That's right. That was one of the things I was allowed to examine.
And yet she still gave you her phone voluntarily, right?
That's right.
You'd agree with me, Mr. Garcia, it's possible to erase contacts from a phone, isn't it?
That's right, although there is a history of such deletion if someone did that.
But it's even possible to erase a contact from a phone without leaving any trace of it, isn't that true?
Well, that's not true, sir. There's always evidence of tampering left.
Well, if it's someone like you who has your expertise, it's possible that you can erase a contact without leaving any trace, isn't that true?
Even for me, it's rather difficult, but I suppose if you had a lot of technical software, then that's possible.
Right. You didn't find any evidence that the mayor tried to delete this number from her phone, did you?
No, I didn't.
In fact, that phone, that wasn't the only thing that you searched, was it?
I also examined the computers at that campaign headquarters, that's right.
Well, not just the computers. Ms. Heisman, she gave you access to all of the devices in her office, isn't that true?
The primary focus of my investigation was the computer.
Well, computers, laptops, right?
Oh, yeah, that's right. I thought they were the same thing.
Tablets, right?
Yes, that's right, sir.
She gave you access to 37 devices in her office, didn't she?
That's right.
And she allowed you to search for certain terms, isn't that true?
That's right. She told me that I was allowed to look for certain specific terms.
She told you you were allowed to search for fraud, right?
That's right.
She told you you were allowed to search for suppression, right?
That's right, sir.
Your Honor, let the record reflect that I'm showing Mr. Garcia a copy of what has been already entered as Plaintiff's Exhibit 2. This flyer, do you recognize it, Mr. Garcia? I can bring it closer for you.
I do.
Yeah, if it's already in evidence, counsel, you can use it any way you want to.
Great, thank you. You were allowed to search for evidence of that flyer, right?
Well, I was allowed to look for specific words in this flyer, that's right.
Right, you were allowed to search for any string of 7 consecutive words in that flyer, right?
That's right, sir. It was pretty easy. It's like pressing Control-5.
Let the record reflect that I'm now showing the witness a copy of what has been marked as Plaintiff's Exhibit 4. It's a copy of the strategy memo.
And that's
Thank
already in two, right, counsel?
Yes, Your Honor.
All right, you can use it.
Mr. Garcia, you were also given the opportunity to look through for that strategy memo, right?
That's right.
Look for any 7 consecutive terms in that memo.
Consecutive terms in the existing files of the computers, that's right, sir.
What did you search through first, Mr. Garcia? A computer, a tablet, laptop?
I started with computer.
Okay. You started with the first computer. Did you find any evidence of any of that in that computer?
Well, I didn't find these specific words in those computers, that's right.
What about the second computer?
None of these terms were remaining on those computers.
What about the third?
The same thing, sir.
Truth is, Mr. Garcia, on all 37 of the devices that you searched, that included the mayor's personal laptop, right?
That's right, that's what Mayor Heisman told me.
And
was
the mayor-
her personal laptop.
And the mayor's computer, right?
At the campaign headquarters, that's right, sir.
Every single one of those 37 devices, you didn't find anything, did you?
Well, none of the existing documents had these words, that's right.
Not even a string of 7 consecutive words from either of those documents, right?
That's right, sir.
All right, Mr. Garcia. You mentioned on direct examination that you can determine, using your cell phone, or excuse me, using your Sebastian physical analyzer, how a number was stored as a contact. Is that true?
That's right, sir. It gives me details about when the contact was stored and how that happened.
Is it your sworn testimony that that Sebastian physical analyzer could tell you that that number wasn't synchronized from anything or wasn't entered some other way?
That's right, sir. It can tell me whether it was saved on the phone or on the computer.
Do you remember preparing a report for today's case?
Of course.
You swore to include all relevant information in that report, didn't you?
That's right.
You recognize if I showed it to you today?
Of course.
Let the record reflect that I'm showing opposing counsel a copy of the witness's report. May I push the witness, Your Honor?
Of course.
Thank you.
That looks like a copy of the report, right, Mr. Garcia?
That's right, sir. Yep.
Can you flip to the back? Is that your signature?
Just give me a minute. That's right. That's my signature.
Can you tell me where in this report you say that you can conclusively say that that number wasn't entered through synchronization or anything like that?
Right here, sir. Bottom of page 5. It's the paragraph title.
Hang on, we haven't moved the exhibit into evidence yet. Is there any objection, guys, or not?
Not at this time, Your Honor.
You want it in evidence, you're just using it for impeachment?
I'm just using it for impeachment purposes, Your Honor.
Okay, well, all right, I'll let him read it. Go ahead.
Thank you, Your Honor. What I was about to read was paragraph 29. A cell phone does not store a phone number as a contact unless a person using the phone affirmatively saves the number as a contact. Merely calling a phone number or receiving a call from that number will not save that number among the phone's contacts. I determined that 625-555-1935 was saved as a contact in Heisman's phone at 11:30 p.m. on February 28, 2015.
You didn't mention the word synchronization there, did you, Mr. Garcia?
No, sir, because it wasn't synchronization.
Objection, Your Honor, to an improper impeachment. May I be heard?
Sure.
In order for opposing counsel to present this witness with this report, which isn't in evidence, and have him read text from it, he needs to show a contradiction between what's in the witness's prior statement and what he's saying in court today. If I could direct the court's attention to the last sentence that the witness just read, I determined that 625-555-1935...
Whoa, you don't have to repeat it.
Yes, Your Honor.
Go ahead.
Specifically, the witness testified that it was saved as a contact in Heisman's phone. That's certainly evidence that it was included in his report, that it was entered into the phone itself.
Ma'am?
Yeah, go ahead.
Your Honor, another thing that we can impeach the witness on is omitting relevant facts from the affidavit. Insofar as he just included in here that he concluded that the number was saved in Mayor Heisman's phone, it is an omission because he said on the stand and testified that he could determine how that number was saved in the mayor's phone. And he didn't include that anywhere in this report.
All right, well, I'm going to permit the cross-examination, but now he knows the answer based upon counsel's comments, so go ahead.
Just to be clear, Mr. Garcia, you never mentioned in here anything about concluding how that number could have been saved in the mayor's phone, right?
That's not true, sir. It says that it was saved via the phone.
Right, that it was saved into the phone. That's what you said.
That's right. That's what I said here. That's what the report said.
Okay. One last thing, Mr. Garcia.
Of course.
You talked on direct examination about how you interviewed a bunch of people, right, who reported getting these false phone calls?
I didn't really interview them. I just visited their homes and they gave me the cell phones to handle.
Right, but you had to speak to them a little bit, right?
I did. I confirmed that they were residents of District Hall, and I looked at their phones to see that they were actually contacted by the 625 number.
Right. First of all, that group of, what, 170 people, was it?
18 was the group of people that gave me the phone, sir.
Well, the total number of people that you spoke to was about 170, isn't that true?
That's right.
First of all, that group, you didn't find that group for yourself, right?
No, the plaintiff's attorneys gave me a list of people who self-reported receiving calls.
Right, Ms. Ginger picked out the group of people that you would examine, right?
No, sir, that's not true. They helped me find the people who reported receiving fraudulent calls.
Okay, and they only gave you 170 people.
That's right, they said only 171 self-reported fraudulent calls.
Okay, only 171 self-reported fraudulent calls, that's what you're saying.
That's right, they set up a little hotline and only those people responded with those claims.
Okay, Mr. Garcia. Of those 171 people who you spoke to and reported these claims, how many of them told you, first of all, that they didn't vote in the election?
Objection, Your Honor. Question calls for hearsay. May I be heard?
Sure.
If I could direct the court's attention to a piece of relevant case law on the third page of the document I've handed you.
And which, that was the, let me see what I got.
Of course, Your Honor.
This is on the available case law?
Yes, Your Honor. It's on the third page. And specifically, the case I'll be referring to is the third piece of case law on that page, Richards v. Mississippi Barbecue.
All right, hang on.
Yes, Your Honor.
All right, go ahead.
Your Honor, opposing counsel is attempting to use Mr. Garcia's testimony as a conduit for hearsay. Now, Mr. Garcia has already testified that he didn't rely on any interview information in coming to his conclusions. So, opposing counsel, in attempting to ask the witness repeatedly about what the people who he spoke to told him, is attempting to use the witness as a conduit for hearsay, and that's inadmissible under Richards v. Mississippi Barbecue, unless the expert can be making some relevant conclusion based on it. Insofar as the witness has already said he didn't base his conclusions on interview knowledge, that's inadmissible.
May I be heard, Your Honor?
Of course.
I'm actually not asking about any statement. In fact, I'm asking about the absence of a statement. My question, if I may, was none of those individuals said to you that they weren't going to vote in the election. And if I may make an offer of proof, I believe his answer will be no. Therefore, there's no statement being elicited. And secondly, counsel certainly opened the door to this testimony when he asked the witness about the 170 people that he spoke to on direct examination.
If I may, Your Honor, opposing counsel is certainly free to ask the witness about whether he asked these people questions, what information he had about them. However, the phrasing of the question he just asked was specifically about statements that the people he spoke to made to him. Insofar as that's the case, it's hearsay under Richards v. Mississippi Barbecue and not being used for an expert conclusion.
May I be heard, Your Honor?
Last chance.
Your Honor, I'm not asking the witness to elicit any statement at all. In fact, I expect his answer will simply be no, that nobody made any statements to him to the effect that they weren't planning on voting or that they were dissuaded from voting. Insofar as that's true, it can't be hearsay because there is no statement, and it certainly can't be being used for the truth of the matter asserted.
Objection's overruled. Yeah, let me ask the question.
Mr. Garcia, of those 170 people, not a single one of them told you that they weren't voting.
No, we didn't talk about the election at all.
Not a single one of them told you that those text messages that they received dissuaded them from voting.
No, sir, I didn't ask them.
Not a single one of those just 170 people that the plaintiff presented to you said that those phone calls dissuaded them from voting at all, right?
No, like I said, we didn't talk about that.
Thank you, Mr. Garcia. Nothing further.
No redirect, Your Honor. I just asked that the witness be allowed to step down.
Sir, your excuse, sir.
Thank you.
And Your Honor, at this time the plaintiff rests its case in chief and would just request a brief 5-minute recess before proceeding with the defenses.
You've got all the exhibits in you want to offer to the jury? You're done?
Yes, Your Honor, though I would ask permission to publish Plaintiff's 5 if was offered into evidence under Mr. Garcia's testimony.
Okay, well, that was listed as demonstrative. You're going to move it as an exhibit?
No, Your Honor, not the demonstrative aid, but specifically the authenticity of Plaintiff's 5. That's the document by NetSource giving the phone's records and activity.
Not the report.
No, Your Honor, not the
I'm
report.
not letting it as reported, but exhibit 5 is admitted.
Yes, Your Honor.
All right, why don't we take 5? Fair enough?
Yes,
Yes, Your Honor.
Adjourn for 5 minutes.